Okay. All right, Mr. Coon, can you see this document?
Yes.
Okay. And there was discussion about that if an absence was on a Friday, then it would have been an absence caused by you. Do you recall that testimony?
Yes.
Okay, so are there any absences on a Friday on this document that were not caused by you?
Yes. If you scroll down to October,
Okay.
the only other one that they said were caused by me, I believe, was the October one. But if you go to the October, that was when the children were still remote learning from the house with Natalie.
Okay,
School,
and so which October are we talking about? There are.
I can't see it if
you can't see the. Oh, it says screen sharing is paused.
No, I can't see if you scroll down where it'll go to October.
Does that work? Okay.
Yes, Friday, October 2nd.
Okay, so Friday, October 2nd, that says unexcused.
Yes.
Okay, and so you were saying that what was the reasoning for why that could not have been your doing?
Because the children were still face-to-face. I mean, we're still online learning at home at that point, and they were with her.
Okay, so when you had Thursday possession while the children were still online learning, what
Yes.
was the schedule from how did you pick up and exchange Thursday through Friday morning?
I would pick them up from the house at school dismissal time 3:25, and I would drop them at the house around 7:50 in the morning on Friday.
Okay, and Ms. Koo testified day before yesterday, regarding it took until, was it 10 a.m. for the children to be listed as unexcused rather than tardy? Is that correct?
No, well, so it took till 10 a.m. At 10 a.m., they're counted as absent for the whole day.
Okay.
And so if they are there before 10 a.m., they're just counted as tardy.
Okay. So if it is listed as unexcused.
Unexcused only means that there wasn't a note written.
But could you describe then, if it says unexcused, then they had to miss at least after 10 a.m. Is that correct?
Correct. They had to be there past 10 a.m.
Okay.
And without an excuse. Correct.
Okay. And so what Fridays were you in possession of the children where there were absences?
January 15th.
Okay. And tell us what happened on January 15th.
January 15th was the date that I took all three of my children to get COVID testing because my son showed symptoms on Thursday, that Thursday, January 14th. They were also shown as absent on January 14th, and that's because they were past 10 o'clock late that day because I picked them up from the school, not from the house. So they were not physically absent as far as not being at school.
Okay. So they had gotten to school, but something
I'm
had
going to
happened.
object. Can I take the witness on voir dire?
You may.
Sir, were you at the school when the children got there on January 14th?
No, sir.
So anything you know or claim to know, you would have either learned from the children or someone else, right?
Yes, sir.
Judge, I'm going to object. It'd be hearsay and ask that it be stricken.
Sustained.
As to which part, Your Honor?
As to hearsay. The exhibit's already in evidence. So I can see they were absent that day, and I heard his testimony. He picked them up from school. But
Okay.
As far as when they got there, that's hearsay.
Okay. Thank you, Judge. Okay. So when you did not take the children back to school on January 15th, what did you do other than get the children COVID tested?
So we went back to my place after that.
Who did you notify prior to getting the kids tested?
The school and Natalie.
When did you notify them?
I notified Natalie on Thursday that I was going to be taking them to get tested on Friday. And I notified the school Friday morning. I sent the email to all the teachers, the VP and the attendance clerk, Ms. Simpson.
And when you told the school and Natalie that they were getting tested, what did you tell them with regard to attendance?
That they were showing, that Kale was showing signs of symptoms of COVID and that I needed to go get him tested.
Okay.
Yes.
And
And I also asked them if there's any schoolwork or anything of that nature that they need him to
They're gonna
do.
object,
and
it's non-responsive.
Sustained.
okay. When were you notified, which dates, if any, of these absences that did not occur during your periods of possession, were you notified by Natalie that she was not returning the kids to school?
The only time I can think of her ever notifying me was very recently. It had to be, if you pull it back up, it had to be one of the most recent ones where she told me that Sonora wasn't feeling well. It was just a couple of weeks ago, I believe. But that's the only time I've ever been notified of an absence. Yeah, it had to be, if you go down to Sonora's name. Right there, March 4th. That was, I believe, March 3rd and 4th, I believe, was the only time I've ever been notified of an absence.
Isn't March 3rd and 4th 2 days? So how could you only be notified?
Hello? Sorry, I'm here. Per your temporary orders, do you recall if Natalie is required to notify you if the children do not return to school?
I believe, I think that is true, yes.
And other than the March date, you said that you've not received any notification of the kids not going to school.
Correct.
Are you asking the court to consider Natalie's violence against you in the last 2 years and appointing you sole managing conservator?
Yes.
You mentioned that Natalie's drinking had increased prior to filing for divorce. Is that correct?
Yes.
Can you describe Natalie's behavior after she had been drinking?
Yes, it was very erratic. It would oftentimes
Explain to the court what erratic means.
never know what she's going to do next. Come home after drinking and driving, come home, turn music on, come home to harass me. She would be hungover the next morning, not wake up, which is why a lot of times.
It's non-responsive at this point.
Sustained.
Okay. After she had been drinking the next day, could you describe her behavior the next day?
Yes, she would be hungover and oversleep. So I would get the kids ready for school.
What would her behavior be that you would know she was hungover?
Headaches, still passed out. Sometimes she would even still be drunk in the morning because she was out so late.
How would you
Drinking.
know that she was still drunk?
Because we've been together for a long, long time. I know her behaviors when she's been drinking.
So what were those behaviors that allowed you to identify that?
It's all her actions as far as just the way she talks, the way she behaves.
Non-responsive.
Overruled.
Describe the way that she would talk that would let you know she was still drunk.
It would be a lot more hostile. It would be a lot more impulsive. It's a lot more, I guess volatile is a separate word from hostile, but it turned very, very negative. The behavior was very, very negative.
Was there anything that you observed as far as her behavior, her speech that you could identify to the court that would let you know that she was hungover or that she was still drunk?
Yes. Well, number one, when you can still smell the strong smell of alcohol on her breath in the morning as well when she wakes up, or if I'm being
Object, it's
told,
not responsive.
Overruled.
You can continue.
And she would outright tell me sometimes she's hungover or she still feels drunk. I mean, I mean, there's so many ways to describe it. I'm not sure how else I can say it, but
What, if anything, in her physical demeanor allowed you to know that she was not herself, that she was possibly still hungover or drunk?
the fact that she wasn't able to wake up on time, the fact that she would have massive headaches from over drinking, the fact that I wouldn't trust her to drive in the morning.
Objection,
Definitely.
non-responsive.
Sustained.
Okay. When you describe her behavior as erratic when she drinks,
Yes.
would you say that the video of her the night that she was arrested was similar to what you are describing?
Yes. Yes.
Is that the kind of behavior you saw often?
Yes.
Have you seen that same behavior since January of 2020 when we had the temporary orders hearing?
Since January of 2020, the original. Yes. I mean, the day after she got out of jail, she came and smashed the windows out of the house.
Sorry, let me,
Object. May I take the witness on voir dire?
May.
I'm actually just going to object to non-responsive. That was
All right. Sustained.
after the temporary orders hearing in January of 2020. Did you see any of that behavior in Natalie after the temporary orders hearing?
Well, yes, I mean, to me, it's almost self-evident in the tardies and lateness on Fridays. And
Objection, non-responsive.
Sustained after yes.
Are you asking the court to order that the other parent be notified after appointments are made for the children regarding
Yeah.
health and welfare?
yes,
And is that something you would do if you made an appointment?
yes, I have done it.
Objection, non-responsive after yes.
Sustained.
Let's just talk briefly about the kids. So Kai's the oldest, correct?
Yes,
He's how old?
he's 10.
Could you describe Kai for the court? Not physically, but Kai as a child.
Kai is a child. Okay. Kai's he's my most particular child. He is, he's very studious in regards to loving to learn. He's very particular in regards to how he likes things done. Him and I like to study things like about space together. We like to do Rubik's Cubes together. Unfortunately, because of COVID, we haven't been able to go to competition the past year, but excuse me. Kai he's like a little mini adult almost. And he's a bit of a worrywart. He overstresses himself a lot sometimes. And so I have to rein him back in. And let him know, hey, enjoy being a child while you can be a child, son. Don't want to be adult just yet. He's so special in his way. But I have to give him a certain balance in his life to make him
responsive at this point.
Sustained.
Okay. So, and you mentioned the Rubik's Cube. Could you tell the court what Kai was previously doing with the Rubik's Cubes prior to COVID stopping that?
Objection, asked and answered.
Overruled.
So we started doing Rubik's Cubes when he was 7. That I asked him he asked me, he didn't know what to give me for my birthday. And I told him,
Responsive.
Sustained.
Okay, so how did Kai get into Rubik's Cubes?
he got into Rubik's Cubes involved with me. He was giving it to me as a birthday present, being able to solve a Rubik's Cube.
And
And so
and
then
since that time, so that was 3 years ago?
yeah, almost 3 years ago.
And since that time, what has Kai been doing with Rubik's Cubes?
We've gone to competitions, multiple competitions. We learn together. We practice together. We
And
judge.
how does he do in these competitions?
He does really well. It's really cute. And it's where he fits in socially too.
Objection, non-responsive.
It's sustained after he does really well.
And is this a bonding experience for you and Kai?
Yeah.
Objection, leading.
Overruled.
And let's talk about Kale, your middle son. How old is Kale?
Gil's 9.
And could you describe Kale's personality for the court?
Yes. Kel, like his father, wears his emotions on his sleeve. He's a very loving, caring person. He loves, and I mean loves turtles and all animals in general. Anytime we go to the beach, we bring a trash bag because we like to clean the beach up and clean trash up. We love to go fishing with each other, camping with each other. He loves being outdoors, and he's a very, very caring person who just wants to be heard. And he can get very upset if he doesn't feel like he's listened to, which is sometimes why he might have problems and things like that.
So which child is this? Which of your children is this?
Sorry. That's Kale.
And which child? Here, I'll do this since we just talked about. And who is this?
That's Kale.
When were these photos taken?
His birthday last year. I believe that was his birthday. Oh, hold on. That might have been before his birthday, actually. We've gone camping a few times. I'm trying to remember exactly which one that is so I can tell the truth.
It's okay. It was recent.
Yeah,
Okay. And who
yes.
is this?
That's Sonora.
Okay. And so why don't you, well, what are you two doing in this photo?
Oh, we were just playing dress up. She was putting earrings on me and doing my nails.
So could you describe Sonora's personality for the court?
Yes, Sonora's very, very bubbly person. She's my extreme extrovert. She loves to make friends. I mean, loves. She's the one who always wants to laugh about something. Anything's funny to her, which is great for me because I can tell dad jokes. Her and I have a little thing going on right now where we both write our own jokes down and we critique them with each other and try and make them funnier. So we save our jokes for each other for that. Sonora loves pampering. She loves to pamper my sons and myself. She makes us sit down on the couch and she'll pamper us, and I've always got some sort of sparkly on my nails. Unfortunately, it's been a while since I've seen her, so I don't have them anymore. They're washed off.
Objection, non-responsive.
Sustained.
And how would you describe your relationship with your 3 children?
I think it's an amazing relationship. It's grown so much as well.
There was an injunction discussed earlier regarding your brother. Could you state your brother's name for the court?
Hi, David Koo.
And has your brother ever been around the kids?
Yes, within family gatherings, yes.
And how long ago was that?
Years ago. I think I don't even know if he's ever met Sonora. I don't think he
And-
has.
Would you ever allow him to be around the kids unsupervised?
No,
Would you even allow him to be around the kids?
no,
Has that ever been an issue prior to Ms. Koo filing for divorce?
no.
Why did you have to tell Sonora about Santa not being real this year?
Her brothers told him. Her brothers told her he wasn't real. They were talking about it in the room, and they told her.
How do you think you are supposed to be able to communicate about telling your child that Santa isn't real if you two cannot communicate about things like Kale's hospitalization?
It's not possible currently.
Do
It's
you
very
think-
difficult.
Do you think that you two have an effective co-parenting relationship at this time?
No,
If you were the primary conservator, what would you do to encourage that co-parenting relationship?
I would continue to do like I am doing now and send emails, send text messages, and let her be aware of things that I feel are very important. For instance, like when I received Sonora, this was probably summertime. She told me that privates were hurting.
As I'm gonna object, it would be hearsay, assuming she is not Ms. Koo.
Sustained.
Can you give an example of how you co-parented regarding your interactions with Natalie in relationship to your kids?
Yes, my daughter's private areas had a rash, so I immediately let Natalie know.
Judge, I'm gonna object. May I take the witness on voir dire?
You may.
Sir, what were you doing with your daughter that you saw that her private areas had a rash?
She told me.
And you knew you weren't supposed to say that because that's hearsay, isn't it, sir?
Objection, Your Honor. The testimony is with regard to my client's co-parenting, not with the truth of the matter of the child's
The-
statements.
He just stopped saying it because he knew it was hearsay, and you just sustained the objection, and then he tried to backdoor it with the next answer. And so I would object that it's clearly hearsay and ask that it be stricken.
The objection's overruled. You may continue with how you handled that from a co-parenting standpoint.
Yes, sir. I immediately contacted her mother immediately, and I also immediately made a phone call. Actually, I'm sorry. I contacted the doctor first and called her immediately after I talked to the doctor and let her know what the doctor said. And then I took her into the doctor, and then I sent Natalie the paperwork from the doctor. And also, while we were there, I got her a 5-year-old wellness check, and which allowed me to get that checkup on her private area for free because it counted as a wellness check. And I sent Natalie all the paperwork as well for that immediately. That's one example.
Um, yesterday, it was brought up that it was alleged that you told the children that God didn't exist. Do you remember that?
Yes.
What have you done that you have actively participated in Natalie's belief system?
Well, perfect example how I have a relationship with Pastor Malcolm is when a couple years ago when Natalie was wanting to get baptized, I reached out to Pastor Malcolm and I asked him, as a non-Christian husband who wants to support his wife, how do I help her through this process the most? And then we ended up meeting on an almost weekly basis and just going over supportive ways to do things, what I can do and say, how I need to. And then he actually ended up letting me know one week that he used me in the sermon.
Judge, I'm
Talk-
going to object. It's non-responsive. I think the question was about the kids.
Same. Well, that wasn't what the question was. The question was about how he supported his wife through the religious stuff, but we're getting into what the pastor told you, and that's hearsay. So,
Yes, sir.
next question.
Do you have other examples in the last year regarding your co-parenting with Natalie that you would like to share with the court?
For instance, anytime there was any kind of COVID scare or anytime there was, for example, when that last week of July, when I had no more vacation time, I let her know that the children were with my sister. My sister came down to Houston and was watching them. I shared who was their caretaker at the time, which was something that was never reciprocated. Homework assignments.
Did you and Natalie have correspondence with regard to who was the caretaker of the children?
In July? About my,
Yes.
yes.
Had there been other issues with regard to communicating who was going to be the caregiver of the children during each of your periods of possession?
Yes.
I'm going to, so Your Honor, it hasn't been admitted. It's marked R52, but I don't know how to give it to him without publishing it when it hasn't been admitted yet.
So he doesn't have a copy in front of him.
I can send it to him.
Well, I was just thinking if you need him to identify a document, probably need
I
to
can do
have
that.
him have.
I'll send it to him.
Unless, Mr. Mahoney, you don't have any objection to her publishing it. Obviously, if it's not admitted, I'm not going to consider it.
And Judge, I understand that, and I'm just looking at it. If I can have just a second, this is the one that came over as we started. So if I can just read through it, I may be able to stipulate to it.
Okay.
Okay, I see it, Kathleen.
We'll just give Mr. Mahoney a second. This may save a little bit of time. If you will please review that while Mr. Mahoney is reviewing it so that you're familiar.
Yes.
Judge, I have no objection to respondents 52.
Okay, I'll just move to admit, Your Honor.
All right. R52 is admitted.
Okay, and so Mr. Koo, is this an example of your co-parenting with Natalie?
Yes.
Have you ever hesitated to provide her with the information regarding the caregivers of your children?
No,
How often do you communicate with Ms. Koo regarding the whereabouts of your children if they are not with you?
it's only been the ones that are always with me.
Objection, non-responsive.
Sustained after it's only been that once.
Um, Mr. Koo, do you have the exhibits 49, 50, and 51 that I sent you?
Let me pull it up. Yes,
Okay. And the first document, can you state for the court what it is?
exhibit 49, Is that
Exhibit
correct?
49? Yes.
child support obligation.
Judge, I have no objection to 49 and it's 49 and 50 are the two child support.
Yes.
Okay. I can't stipulate to the numbers, Judge. I do stipulate to the admissibility of 49 and 50.
Okay. And I feel the same way. So when you get to yours, Mr. Mahoney.
So
Okay.
49 respondents 49 and 50 are admitted.
Okay. And Mr. Koo, let's address then 49, the numbers on here for Natalie. Where did these numbers come from?
Okay, let me go through it real quick. Let's see here. These are based on her given information.
Did you get these from her financial information statement?
Yes,
Okay. And if the court orders Natalie to pay child support, would you ask that they at least order her to pay this much?
if they order her to, then yes.
Okay. And I'll move to admit, Your Honor. I don't know if they were actually admitted or if they were just stipulated.
49 and 50 were admitted.
Okay, thank you, Judge. And go ahead and share. And Mr. Mahoney, did you also stipulate to 51?
Yes, I do.
Okay. Okay, and
Sorry,
Mr.
Judge.
Koo,
Sorry, Judge. Yes,
All right,
I
so
do. Sorry.
our 51's admitted.
thank you, Judge. Okay, and Mr. Koo, regarding your income on this exhibit R50, is this based on your earnings from last year?
Yes,
Okay. And did you take your net income from last year and then divide it by 12 months? Or your gross
Yes.
income and divide it by 12 months?
yes,
Okay. And that includes your monthly health and dental obligation for the children of $114, correct?
yes. Yes.
Okay. And if the court does not use last year's income to calculate the support obligation, are you asking the court to order your obligation based on the average of your year to date to present?
Yes,
And is that what R51 reflects?
yes,
And did you take that, get that number by taking your 7 pay checks, which includes a bonus, and dividing it by your 6 pay periods?
yes.
And then you multiplied it by 26?
And then divide by 12 for
Okay.
the monthly.
And so that came out to $7,528.69.
Yes,
Okay. And if the court should order you to pay child support, you would ask that they consider your last year's income because there's no guaranteed income this year, but in the alternative this?
Yes.
To date, have you earned the same number of, or the same amount of bonuses in 2021 that you did in 2019, month
No.
for month?
No.
So by March of 2019, you had already received more income than you have today, this year?
Yes.
Okay. What do you anticipate with regard to your bonuses in the future based on the building industry?
I honestly don't anticipate one this year. I'll probably get a Christmas bonus. But if I'm going to be starting a new job, it'll be a little bit before I get another bonus. That's how it works.
And by new job, do you mean within your company or within a new company?
No, within my company, we call them jobs, a new job site.
Okay. And when is your current job supposed to conclude?
Now,
Okay. And are there any other jobs that you are able to work in Houston at the moment?
no,
Okay. And we've already discussed that. If you are not awarded the marital residence and you are not able to go to Austin, will you be able to have a rent discount?
no. Yes, at an apartment. Yes. I'm sorry. I was not thinking properly.
If you are no longer employed at your employer, will you have a rental discount?
Oh, no, no.
And so what would your rent be without that discount?
It would double.
Okay. Have you had any further discussion with your employer with regards to your job situation in Houston versus in Austin?
Just
Objection
There-
non-responsive, that's a yes or no.
She's just asking, have you had discussions, yes or no?
yes.
And what have those discussions entailed?
Objection hearsay,
Sustained as to the form of the question.
What do you know and what are you relying on with regard to requesting your move to Austin? In regards to your job situation?
I'm. What do I know about my? Can you ask that again? I'm sorry.
What do you know about your current job situation?
That I currently don't have a position here in Houston right now.
You provided 401k information, which was produced in R 40 through 43, which also includes the summary plan description. Are you asking that if the court awards Ms. Koo any of your 401k, that she be responsible for the cost of a qualified domestic relations order?
Yes.
And does the information you have provided for the court, is that sufficient for her to be able to do as much, to have a qualified domestic relations order drafted?
Yes.
if you are granted the exclusive right to designate the primary residence of the children, will you begin taking Kale to therapy?
Yes.
You were asked previously if you had contacted the therapist to get the children's therapy sessions. Do you recall that?
Yes.
Have you ever had a doctor or a therapist call you to tell you that a child had an appointment?
No.
Do you regularly call the children's medical providers to find out if they have appointments?
No.
You think that's reasonable?
I'm sorry.
Do you think it's reasonable to have to call the children's medical providers to find out if they have appointments?
No.
In the last year, what projects have you done with the children with regards to school?
Um, one of the fun ones was we did an oobleck project, which is basically just cornstarch and water. That was an assignment due on non-Newtonian fluids, which can act like a liquid and solid. But that was one of them. On a regular basis, Kai's got a current project going on right now that he's working on, that he's saving for me. He says I bought him a poster board for it because he wasn't going to use. He was just going to write it on a piece of paper.
Jackson, hearsay.
Sustain.
Okay. If you are not awarded the house or the house is sold, are there items in the marital residence which you want to take possession of or be awarded in this final divorce?
Yes.
Could you, other than the Corvette, which you've asked to be awarded as your separate property, could you tell the court what items you are asking to retrieve from the marital residence or be awarded in the marital residence?
Yes. All of the tools and ladders and my ladders and one of the ladders in there actually belongs to my father.
Could you describe what that ladder is like so that if someone were to see that ladder, they would know which it was?
Yes, it's a 6-foot aluminum ladder.
Is it a color?
Aluminum with stains all over the top.
So it's a silver metallic?
Yes.
Okay.
Yeah.
Okay. Anything else?
Yes, all of my fishing gear.
Is there any fishing gear with relation to the children in addition to fishing gear for you?
There is. I'm not sure if I have all of it with me or not. So if there's any in relation to the children, I would like to keep that as well. I would like to. And this is if I do not have the house. Is that correct?
Either way, if you have the house or if you do not have the house, what items are you asking the court to apportion to you in this division of divorce?
Okay, so if I do have the house, then I obviously need the washer and dryer and refrigerator and things like that to stay. I can't have that be taken away. I'd like the couch to stay there because that was the one thing I was able to pick out in the house and I liked it.
So you would like for the court to award you the couch in what room?
The living room. I don't know if it's still in the living room, but that's where it was.
Could you describe for the court what it looks like?
Yes, it's a brown sectional couch with recliners.
Okay, is there anything else?
Um, not that I can think of right now, no.
Okay, so there's nothing else in the house, no electronics, personal property. I want to make sure we're
Oh.
thorough on this.
Yes, I want my PlayStation back. Yeah.
It's the PlayStation 4, correct?
Yes, the PS4.
Is there
Mhm.
anything else with regard to the PlayStation that is currently at the house?
All of the games and the wires for it.
Are there any other electronics that you would like the court to award you?
Well, there's 3 TVs in the house and 1 projector. The projector, I would like to be able to keep that. And it's just it's hanging in the garage currently. So, and then I was gifted a TV from my boss that's in the master bedroom. About 4 years ago, he gave it to me. No, geez, that was 6 years ago. It's a 55-inch TV. I'd like to be able to keep that as well. And then she can have the other 2 TVs.
Okay, 55-inch TV in the master. And are there any other electronics that the court should award you?
I would like to at least have access to that hard drive that's disappeared somehow.
What hard drive?
It's an external hard drive with lots of pictures on it of my children and things like that, as the pictures that I want, at least.
So you'd like to have access to digital copies of the photos of the children on an external hard drive in the house?
Yes.
Okay.
Yes. There's lots of baby pictures and things like that.
Okay. Does that conclude all of the electronics?
We're not talking about kids items, are we? Just stuff for myself personally. Is that correct?
Kids items as well, if there are things regarding children.
Well, just that their electronics go back and forth between us. Currently, Kel's not allowed to bring his back and forth.
His what?
His tablet.
Okay.
It stays with her.
So you're asking that the children be awarded their tablets and that they be ordered to go back and forth per the temporary orders, or similar
Yes.
to the temporary orders?
Yes.
And is that the same tablet that you purchased for them in December of 2019?
No, that one got broken. So she bought that one for him for Christmas this year. One of the things she couldn't remember. And then he's not been allowed to bring it back and forth though, because she
I'm
bought it.
gonna object. It's objection hearsay. An objection, some facts not in evidence.
Overruled.
Okay. Are there any other electronics with regard to either yourself or the kids?
No.
Okay. And what about personal items for either yourself or the children that are in the residence?
Well, in regards to clothes, we need to be able to share those, obviously. I have no problem doing that. I mean, it's our children.
So would you propose to split the children's clothes 50-50?
Yeah, or not, or in all honesty, I don't want it to be so stingy. Like if they happen to wear something that's mine and it goes to her and she doesn't return it, it's okay. If she sends them with something that she bought and we accidentally leave, I don't want it to be a mess. They're clothes, let's just be fluent about it. That's what I want. I don't want the children to feel like, oh, we can't have this here. We can have that there. We can't have no, it needs to be fluent.
And so to start off with, would you propose then that each of you have an equal amount of the children's clothes for them to travel back and forth?
Yes.
Okay.
Yes.
What about, do you have any personal items of your own that is still in the marital residence?
I'm pretty sure I got everything out besides, well, that I could fit in here. You know, the big things were my tools and that one TV, which, you know, and
Do
the
you have any
couch.
personal documents that you need to have the court ordered to turn over to you?
Well, my wallet that had my social and I had to get a new driver's license and everything. That disappeared the same night my phone was thrown in the creek.
Do you have any other personal documents that are still in the marital residence?
I believe that the deeds to the house and things like that are in there. I believe that the children's passports, she still has those.
And what do you propose with regards to possession of the children's passports?
That I would have, I would be in control of them. Obviously, I wouldn't deny access. I mean, it's for the children.
Do you feel the same about the children's other sensitive data documents?
Yes, I do. Yes.
What about your own passport? Do you have that?
Haven't been able to find that. That was in the firebox. And the firebox somehow went missing.
When was the last time you saw the firebox?
When Natalie took it to her friend's house,
Did you see her leave?
she told me she took it there. Along with the computer.
Is that the computer you were talking about with the photos on it?
No, the computer, the photos have been put on an external hard drive. That was in the firebox as well.
Okay. And are you asking the court to order each party to either cooperate with the sale of the residence, or if a party is not awarded the marital residence, to sign all documents necessary to convey that property to the other party?
The wording confused me a little bit at the end. I'm sorry.
If you get the house, are you asking that she sign everything you need to get the house in your name?
Yes.
And vice versa, you would comply with documents if she were to get the house, that you would sign the documents necessary to get that into her name?
Yes.
And if y'all are ordered to sell the house, are you asking that both of you be ordered to comply with the terms of the sale of the residence?
Yes.
And you're asking the court to give some time frame as to the sale and compliance to make sure it happens?
Yes.
Are there any other items? We've talked about personal items. We've talked about some furniture. We've talked about electronics. Are there any other items in the residence that you are asking to be awarded to you? Are there any other items that belong to your family that are in the marital residence?
That's what I'm trying to think of right now. If there's anything that's, I don't believe so. No.
Okay. Are there any things that relate to holidays, which you are asking to divide or be awarded to either party?
Judge, I'm okay with us reserving this issue for entry, and depending on what happens with the house, we can litigate it, maybe submit it. I mean, I don't.
Your Honor, I don't know if you remember our last entry.
I think we're wrapping up this line of questioning, so I'm going to allow it. Overruled.
Do you have anything with regard to holidays, which you are asking to divide or be awarded to either party?
Just presents that the children are allowed to take their presents back and forth, or.
Okay. So are there any decorations in the house that you are asking to be awarded to you?
No.
Okay. Do you have any weapons that need to be addressed?
They're in Fort Worth.
Are you asking that those be awarded to you?
She can keep that shotgun if she wants it. It's fine with me.
What is that shotgun?
It's a little home defense shotgun. It's a Remington 870, a junior. I honestly bought that for her, so if she wants it, she can have it.
Is it registered in your name?
Yes, I believe so.
Okay. If the court were to award it to her, would you ask that it be registered in her name?
Yes. Yes.
Is there anything else that you are asking? Are you asking that all of the items in your apartment be awarded to you?
Yes.
And do you have anything of significant value in that apartment?
The TV, I guess. Other than that, no.
Could you describe the TV for the court just so that it can be addressed in the record?
Yes, it's a 75-inch TV. It was $1,800.
And
believe.
when did you buy that? Last year?
I bought that, I think it was 2 years ago.
So you bought that actually prior to filing for divorce?
Oh, yes, yes,
That was actually awarded to you in the temporary orders, is that correct?
yes.
Then if there is no other items in the marital residence that you wish to be awarded to you, I'm going to pass the witness.
May I proceed, Judge?
Mr. Mahoney, your witness.
Thank you.
You may.
Sir, you remember back on Tuesday when I called you at the beginning, or when I first started asking you questions, one of the first questions I asked you was about honesty. You remember that?
Yes,
And I asked you if you thought it was important to fully disclose any information you had. You remember that?
yes,
And in fact, you told me that you believed in honesty and full disclosure, and that's what you were doing, right?
yes,
And you remember we had a little discussion about your 2020 income. You remember that?
yes,
And I asked you specifically, in fact, I told you that I didn't have, at that time, didn't have any 2021 check stubs. You remember that?
yes,
And then I said to you, Mr. Q, did you get a pay raise between 2020 and 2021? Do you remember me asking you that?
yes.
And do you remember what you told me?
I don't think I did. Yeah, I told
You
you I
don't
don't think I got a
remember-
raise.
I'm sorry?
I told you I didn't get it. I don't think I got a raise. Yeah,
In fact, you told me that your pay was exactly the same, right?
Yeah.
And in
Mhm.
fact, your attorney objected to the question, and the court,
Objection relevance, Your Honor.
well, we're gonna, okay, sir, you told me specifically you didn't get a pay raise, right?
yes,
Okay. And so, sir, I'm going to show you what's been admitted as respondents number 4. And, well, before I go there, let me make sure I understand correctly. When you started your case yesterday with your attorney, if I understood you correctly, you said that you had listened to Ms. Q's testimony and you were astonished that about 3 to 5% of it was correct. Is that what you said?
yes,
Which you understand, sir, means that if she said 100 factual sentences, only 5 of them were right. Is that your testimony?
yes.
Okay, and that's not an exaggeration, right?
No,
Okay. And so if we look at respondents number 4, you see respondents 4 there in front of you, sir?
yes,
Okay, and if we look at respondents 4, you see right in the middle where it says your rate of pay,
yes,
and it says that for period start date 11/21/2020, your rate of pay was $51.9231 cents. Is that what it says?
yes,
Okay, so that was your rate of pay in 2020, right?
yes,
Now, let me show you the check stubs that you produced yesterday. that have been admitted as respondents 38. Okay, do you see those there in front of you?
Yes.
And sir, what does it say that your rate of pay was in January 15th of 2021?
53.3645.
Now that's dollars per hour.
Yes.
That's part of your salary, right?
Yes.
Now remember, I told you I was from Pasadena, right?
Yes.
And we're slow.
Objection relevance.
Well, sir, is there a difference between $51.92 and $53.36?
Yes.
Well, sir, then why did you tell the court under oath that you had not received a pay raise?
Because I didn't realize I did, to be honest with you.
So your company just started paying you more and didn't even let you know? Is that what you want the court to believe, sir?
That's actually exactly right. Normally I get a phone call if we get a raise. I didn't get a phone call.
Non-responsive after, that's exactly right. Okay. Now, in addition, sir, that wasn't your only misrepresentation, was it?
Not to my
Objection
knowledge.
unclear.
Well, sir, do you,
Thank you.
sir, do you think that it was a misrepresentation to say that you didn't get a pay raise between $51.92 and $53.36?
I was not purposely misrepresenting, if that's what you're asking.
Well, sir, and I appreciate that, but my question was, well, when you start talking about $2 an hour over a 40-hour week, that's a fairly substantial raise if you take it over the whole year, is it not?
I would consider that probably a cost of living raise.
Well, sir, I didn't ask what you called it, but it's a couple $100 a month, is it not?
No.
I'm sorry?
No, not after net. It wouldn't be.
Well, sir, how do you know? You just told us you didn't even know you got it.
Because I'm doing the math right now.
So what's the math, sir? How much is it?
Well, it's not $2 completely. If you could bring the other one back up, I could pull up the calculator, but I'm doing rough math in my head.
Well, I'll tell you what, I'll help you with it, okay?
Yeah.
So if you take an 80-hour week or an 80-hour pay period, and you take the $53 and 53.3654, that equals $4,269.232. You follow me?
For a full year?
Well, no, sir. That would be for an 80-hour period.
Oh, you're just doing what that is. Okay, go ahead. Sorry.
Okay.
Yes.
And then you multiply that times 26 because you get 26 paychecks a year, right?
Yes.
And so that equals $111,000.032 over the whole year. You follow me?
Yep. Yes.
So then if you
Sorry.
divide that, sir, by 12, that equals $9,250 a month. Do you follow me
Okay.
so far?
Yes.
Okay. Now, so that would mean based on this pay rate that your base salary is $9,250 a month, right?
Gross.
Gross. I understand gross,
Yes.
but that's what it would be, right?
Yes.
Okay. Now, if we go back though, and we multiply the other number of 5192, sorry, 5192.31 times 80 hours, that's $4,153.848. If you multiply that by 26, that would be $108,000, correct?
What's the full number?
108,000.048.
And the other one was the new salary?
well, this is the old salary, but it would be or it would be per pay period, 4153.848.
Okay.
Okay, and if you multiply that times 26 and then you divide that by 12, that means that your gross pay last year was $9,000 per month,
Exactly.
0.004. So I would call that $9,000. Do you follow me?
Okay. Yes, sir.
Okay, so the difference then, before we even talk about any bonuses, is at least $250 a month, right?
Yes, sir.
Now, when you take out some taxes, it may not be a full $250, but
No.
there's a
It won't
difference,
be.
is it not?
Yes, there will be yes, there will be a difference.
Okay. Well, sir, in addition to that, you then get bonuses, right?
It's yes. I get bonuses if
Objection,
earned.
non-responsive after yes.
The same.
And so if we're interested in full disclosure, okay, let's look at the exhibits that you brought to the court today. You with
Okay.
me?
Yes.
Okay. You told the court a few minutes ago that your monthly gross wages were $7,528.69. You see that?
Yes.
Well, sir, what happened to the other $1,750 before bonuses?
Actually, I added up my paychecks to this point, and then I multiplied it out, and then I divided it. So
Fair
I took my
enough.
paychecks. So I was using the new number that was unfortunately not disclosed, and I took my paychecks from January till now, multiplied it out, and then divided it.
Fair enough. That's in respondents 51, right?
Yes.
Okay, but let's look at respondents 50. Because respondents 50, you told the court under oath, was your taken into consideration all of 2020. You remember that?
Yes.
Okay. Well, sir, you told the court under oath that based on the exhibit that you admitted, your monthly gross wages were $6,710. Is that right?
Yes.
Well, sir, what happened to the other $2,290 a month that we just saw on your paychecks?
I don't know.
Is this your idea of full disclosure?
Yes. To my,
Okay.
I did the best of my ability. Yes.
And sir, could you tell the court why you have 3 children, but you only want to pay child support for one of them?
Objection argumentative,
Overruled.
calls for a legal conclusion.
Overruled.
Well, sir, if you know, where did you come up with the $6,710 a month as your gross wages?
Like I was just saying, I took the paychecks, I multiplied it out, and then I divided it up between the months.
Well, sir, you said that about respondents 51.
Yes.
Okay,
Well,
well,
it's the same form. I mean, I did it for both of them.
well, sir, if you did the same thing for both of them, wouldn't they be the same number?
It's different numbers. It's different dates.
No, I'll agree with that. But my
Yeah.
question is, how did you get 6710?
I answered that already.
Okay. Now, you weren't trying to mislead anybody, right?
No, sir.
Okay, well, let me show you, sir. Do you remember? You remember back in November of 2020, you came before the court and told the court you needed some relief financially. You remember that?
Yes.
You filed a motion with the court and told the court that you couldn't pay all these bills anymore and you needed to modify the support. You remember that?
Yes.
Okay. And sir, I'm going to show you Ms. LaFever, have you seen petitioners 34? I mean, I know you've seen it. I sent it to you over the lunch hour, but I don't know if we
You
have a
mean my
stipulation.
motion?
That's your motion to modify temporary orders.
I'm gonna object to relevance at this point.
Well,
So, I mean, I'm not gonna stipulate to it at the moment. I'm not sure what my motion for temporary orders has to do with our final trial at the moment.
and I'll show you, I'm not offering it for, well, I guess I can have him identify, Judge. I mean, he's, clearly it's in the court's file. It's a sort of, well, it's a
I
copy.
have no problem with the court taking judicial notice of the entire file.
And, okay, well, but I need to show it to the witness. So I guess I'd ask the court to take judicial notice of the contents of the file. At this point, specifically, the motion to modify temporary orders filed on November 25th, 2020.
And based on Ms. LaFever's comment that she's not objecting to that, the court will take judicial notice of that motion to modify temporary orders.
Okay. Now, sir, Judge, may I show it to the witness? I mean, I know it's not admitted at this point yet, but
I think let's ask him, if you've got a question about it, see if he knows the answer to it. And then if he doesn't, then we can do it that way.
okay. Sir, do you remember filing a motion in November, on November 25th of 2020, coming before the court and specifically stating that due to COVID-19, respondent has not received bonuses for 2020 from his employer?
Yes.
Well, sir, why would you say that in November of 2020 when you got a bonus in August of 2020?
Because it's not the same amount of bonuses as the previous year, because we didn't finish and didn't get the same bonuses.
So, sir, the statement respondent has not received bonuses for 2020 from his employer, you think that is saying that you haven't received the same amount of bonuses?
No.
Objection calls for a legal conclusion.
Overruled.
Sir, were you fully disclosing your income when you told the judge that you hadn't gotten any bonuses for 2020?
Yes, I submitted all my paperwork. All my checks for that, when I submitted that, yes.
You submitted all your checks to the court?
Yeah, I believe I gave everything to my lawyer for that.
Okay. Sir, you agree with me that that was a misstatement in November of 2020 to say you haven't got any bonuses, wasn't it?
If it taken in that context, I mean,
Mr. Mahoney, I'm just gonna go ahead and agree to the
Sure.
exhibit so that we can go ahead and,
I'm sorry?
I'll just go ahead and stipulate to the exhibit. I think it'll clean some of this up and make it a little bit easier. So we'll just stipulate.
Fair enough, Judge. I'd offer petitioners 34.
P34 is admitted.
Sir, I'll show you what you filed to come before the court in November of 2020. You see that there in front of you?
yes,
Okay, do you see where you say respondent has not received bonuses for 2020? Do you see that?
yes,
Then you say that respondent's bonus information from 2019 was used to determine your obligation for the community debts going forward, right?
yes.
Do you see anywhere in there, sir, where it says that you've received bonuses, but they're less?
No, but that's what those two sentences are referring to.
Objection, non-responsive after no?
Sustained after no.
Okay, and sir, you acknowledge now that you, in fact, actually had received a bonus 4 days before you filed this motion. Did you know that?
No,
Well,
not in
sir,
November.
I'm sorry?
My bonus was August.
I appreciate that, sir, and let me help you. I'm sorry. Well, no, actually, I was right. Even in my math, 11/21/2020. That's
Yes,
4
sir.
days before 11/25, right?
But look at pay date, 12/11. Go back up, please. Can you please go back up? I was given that check on 12/11.
I'm sorry, you're right. So the period start date, you didn't get it till 12/11. So you didn't know it was coming?
No, I didn't know I was getting my Christmas bonus that early. No,
Well, you didn't know you were getting it that early. When do you normally get it, sir?
middle of December. But I guess that is pretty early. Well, they put it on for 11/21. I normally think it comes in December. So as you can see, period start date 11/21. That's much earlier than I would anticipate. November, and 1 full month earlier than Christmas.
Sir, wouldn't it make sense for you to get your bonus, the pay period before Christmas?
Objection calls for speculation.
I'll rephrase, Judge. I'm sorry, I didn't hear.
I sustain the objection.
Okay. Well, sir, is it your testimony that you don't get your bonus, your Christmas bonus every year on the first pay date in December?
Sir, I didn't know if I was even going to get a bonus. This was been a COVID-19 year.
Non-responsive.
Sustain.
Sir, do you not get your Christmas bonus on the first December check every single year?
I believe I do.
Okay. And so you've told us a minute ago that you knew you were getting a Christmas bonus, but you didn't know it was coming that early, right?
No, that's kind of misstating it. I didn't even know if I was going to get a Christmas bonus. This has been a very bad year.
Well,
Very
sir,
bad year.
Why?
I mean, how?
Why did you just tell us that you didn't know that your Christmas bonus was coming that early?
Well, because you're saying period start date 11/21. How I wouldn't expect 11/21 as my Christmas start date. I mean, for my pay right there. That's
I object to
that-
relevance at this point.
Sustain.
Okay, sir, do you remember telling the judge yesterday that your work day, I think you said it starts at 9 o'clock, but it's flexible. Is that what you said?
No, I did not say that.
Okay, what time does your work day start, sir?
I said it varies upon what's going on at the job at the moment. But if I were to have to put a typical start time, it would be 7 o'clock.
Okay, and so how long, the project that you just finished was in Sienna, right?
Yes, sir.
And how long had you been assigned to that project?
Oof, I've been on here for a year now.
Okay.
A year and like a month or a year and 2 months.
Okay, so about, call it 14 months?
Yeah, we'll say 14.
Okay, now you testified that it was a joint effort to get the kids to the school bus. Do you remember that?
Yes, sir.
And in fact, you did it as much as Miss Q is what you said, right?
I said it was a joint responsibility.
Okay, well,
Yes.
did you not tell the judge you did it as much as she did?
I said we share. I'm sorry. I said shared responsibility, I believe.
Okay,
And towards the end, I would do it a lot. Yes.
sir, could you tell the court how you would put the children on the bus at 7:30 and then drive to the Woodlands and be there by 7 a.m.?
To the Woodlands. My job is, what are you talking about in the Woodlands?
You don't remember spending 3 years on a project in the Woodlands, sir?
If I were to spend 3 years on a project, I'd be fired.
Objection, non-responsive.
Sustain.
Sir, where was the project before Sienna?
It was in Barker Cypress.
Okay, where was the project before Barker Cypress?
It was in Riverstone, which is 10 miles from my house.
Right around Sienna, correct? Were you
Yes, sir.
next? Sir, is it your testimony that you haven't been assigned to any projects in the Woodlands?
Yes, I have.
Objection relevance.
So, well, Judge, it goes to the credibility of,
Overruled.
sir, when were you assigned to a project in the Woodlands?
Let me do the math on it. Hold on. It would have to be probably about 4 to 5 years ago, I believe.
Okay, right around the time that Sonora was born, is that right?
Sonora was born. Yes, it was. No, she was about one or so. Whenever, yeah. So
Okay, and how old is she now?
she's 5. She's about to turn 6.
Okay, and so
So-
when you were and how long were you assigned to that project in the Woodlands, if you remember approximately?
I was sent there to clean that job up. So I was there for about 8 months, I believe.
Okay, so when you were there for those 8 months, who would put the kids on the school bus?
That would be her, Natalie.
Well, didn't you tell the court yesterday that y'all shared in the duty equally?
Yes.
Okay,
Objection mischaracterizes testimony.
He's answered it.
okay. Well, sir, you agree with me that at least for those 8 months, you weren't sharing in the project equally, or in the putting them on the bus equally?
Yes.
And when you went, how long were you at Barker Cypress, sir?
18 months, I believe.
For those 18 months, were you sharing in the putting them on the bus equally?
Yes.
So how long would it take you to get to Barker Cypress?
It would take me about an hour.
Okay, so how do you put the kids on the school bus at 7:30 and get to work by 7?
I would show up late.
Every day?
Not every day.
Well, sir, then you remember you told the judge that your work is flexible, so oftentimes you would be there in the afternoon when the kids would come home. Do you remember that?
Yes.
You weren't exaggerating, right?
No.
Okay, so if the kids get off the school bus at 3:30,
3:42.
I'm sorry, 3:42. You're right, 3:42.
Yes.
You would leave work at 2:42 to be there to get them off the school bus?
Oh, yes, sir. I'm leaving work now at 2:20.
One day a week, right?
Yes, sir.
That's not sharing equally, is it?
Not right now. If I could pick them up every day of the week right now, I would.
Okay, but sir, my question is, what were you doing? Let's start with the 8 months that you were in the Woodlands.
Okay.
Were you sharing equally at that point?
Not for those 8 months. And getting the children on the school bus, no.
Sir, I'm talking about
4.5
picking them up
years
when
ago.
they got home, like you told the court yesterday.
4.5, 5 years ago, for those 8-month period of time, that was not shared equally. I was working a lot.
Sir, I'm asking about the 18 months that you were at Barker Cypress. Is it your sworn testimony that you were equal amount of the time you would leave work at 2:42 to get home and be there with the children a couple of days a week?
Yes. At Barker Cypress, yes.
Now, is this the same math that you used when you told the court that Miss Q would go out on average 3 nights a week during the school year?
It's not math. It's my experience.
Okay. Well, sir, you understand that sometimes there's evidence, like with documents, like check stubs, right?
Yes.
And then sometimes there's evidence with like text messages, right?
Yes.
And do you have any evidence other than your word that any of this stuff is true?
If I were to go back, I guess I could look at pictures or, I don't know. What else am I supposed to say to that?
Sir, you're here today and you've been here for the last 3 days,
Yes, sir.
fighting for custody of what you said were the most important thing in your life, and you didn't have time to go back and get your evidence together?
No, I'm not saying that.
Okay, well then where is your evidence?
I've presented all my evidence.
Do you have one piece of paper that would support showing that Natalie was going out 3 days a week?
Not at that time, because I was not in that mental standpoint to think I need to collect evidence.
Well, sir, you told the court this was right at the end, at the same time that you were filming, right?
Barker Cypress ended, yes, near that time, but the job, like I stated already, was about 18 months long. And yes, the behavior started around, slightly right around Barker Cypress start time. So whenever I'm in that point in my marriage, I was still trying to save it. I'm not documenting what she's doing wrong. I'm documenting what I can do to make it right. So no, I don't have a bunch of written down evidence of what she's doing wrong. No.
Sir, do you remember telling the court a few minutes ago that if you're awarded custody, then the court can look to the co-parenting that you've done over the last year to see what to expect in the future? Is that right?
I didn't say that. I gave examples of some co-parenting. Yes.
I'm sorry. And then your lawyer, I think, said, is this the type of co-parenting that you would implement and continue in the future? You remember that?
Yeah. Yes, with open communication, yes.
Okay. And just so that I understand, you're telling the judge that if you get custody, this is how you're going to communicate with the mother of your children, right?
In regards to emails only and things like that,
In regards to any way.
I'm hoping it can get much better than that. I don't want everything to have to be so specifically this. I want it to be open.
Well, sir, could you tell the court how good this communication was?
I've answered that already. I answered her in email.
You answered her in email?
We're referring to the freeze again, correct?
Sir, are you telling this judge under oath that you responded to her in email after you picked up the children?
No.
Okay.
That was before.
Okay. Well, sir, my question is this the type of communication that the judge can expect from you if you're given custody?
No.
Sir, I thought you said you were going to continue doing what you've been doing. Did you not say that to your lawyer?
I specifically said I will continue doing she was referencing those emails and how I was trying to openly communicate. And yes, I'm going to try and continue to do that.
Okay. So
This is an extenuating circumstance. And like I said, I testified to this already yesterday, that I honestly didn't even see that late, the 6:55 text messages. I didn't even notice that stuff until after.
I understand, sir, but my question is, you told us yesterday there's nothing wrong with this. Do you remember that?
I don't want to agree with you because I want to try and remember exactly what I said. So give me a second. I said there was nothing wrong with me having answered her in the email. That's what I believe I was talking about. Which
Okay,
I
well,
did
sir,
twice.
is there anything wrong with you not answering these simple questions that she was asking here?
I did not see those when they first came through.
Sir, is there some rule that says if you don't respond to a text message when it first comes through that you can't respond?
At this point, she had already spoken with the children and the cops. I've already told her everything was okay when I noticed those.
Sir, if that's true, where's your evidence that she spoke to the children that weekend?
She spoke to them that next morning. I'm telling you because I was here.
Sustained.
Sir, where is your evidence that what you're saying is true?
I'm saying it because I'm the evidence. I witnessed it.
You don't get a phone bill?
Objection asked and answered.
Rule.
You get a phone bill, sir?
Yes,
Okay. You get a call log? You have a call log?
I believe so. Yes.
If in fact she had talked to the children, you've now had 2 days to produce something to back up your story, haven't you?
Yes, I guess.
And as we sit here today, you got nothing, do you?
Would you like me to do it now?
Sir, I remember she's the one that got stuck with the hillbilly, not you. So I'm asking you, when this judge is going to make the decision, the most important thing in your life, and you didn't think to back up your story?
Objection, relevance.
Sustained. Let's move to another topic. I think we covered
Yes,
that
sir.
one quite a bit yesterday.
Yes, sir. Now, sir, you testified that, well, let's talk about the therapy. You remember yesterday telling the court that, if I understood correctly, the children haven't been to therapy, and the reason why you couldn't schedule therapy in July was because they had all been discharged?
So no, in July, I asked about therapy, and then I called Ratisha, and they hadn't been. I contacted Natalie first. Okay. Their last session, Kai's was, I believe, in April, and Kel's was in May. Kel went 3 times since the temporary hearings.
Sir, did you tell, let me ask it this way. If your son needs therapy, he was with you for the entire month of July, why didn't you schedule him a session?
Objection asked and answered. Mr. Mahoney covered this 2 days ago.
Sustained.
Okay, sir, did I understand you correctly to say that they had been discharged and you couldn't schedule them a session?
No, I think we're mixing up timelines here.
Well, so there's only been one July since this case started, so we're pretty clear there, aren't we?
Yes.
The incident happened in March. It's only happened one time, right? March of 2020?
Yes.
You just told the judge that you needed to have the exclusive right on psychiatric and psychological because your kids need therapy, right?
Yes.
Okay, so why didn't you get them any therapy?
For the one session in July that he potentially missed?
Well,
Is that what you're asking me?
I don't know, sir. How many did you try to schedule?
He gets 1 session per month.
Who,
That's what he was
Sir.
getting at the time.
are you telling this judge under oath that he can't go more than once a month?
No, that's what he was set up for, was once per month at that time.
Well,
But
sir,
it
you've
been
told the
canceled.
judge you didn't know anything about the therapy. How do you now know that he was set up for once a month?
I told you I haven't heard anything from Natalie about the therapy. I said I spoke to Ratisha myself and via email, which is how you have to pay her via phone call. So you have to call her for that.
Okay, and your testimony is under oath that you spoke to her and he could only go once a month. Is that what you're telling us?
No, I didn't say that. No, but during the
Because that's not
summertime-
true, right?
Correct.
Okay. In fact, you know he was going twice a month for several of those months, don't you?
No,
How many times a month was he going, sir?
he was once. He went once.
Objection asked and answered.
Sustained.
Sir, you remember the discussion we had about Sonora and her birthday?
Yes.
And birthdays are important, right?
Yes, sir.
And is your birthday important to you?
Not anymore. I'm an old man.
I understand. But would it be important to you for your kids to contact you and tell you happy birthday?
Yes, I would like that.
Okay. Well, sir, when Miss Q, and I'm probably not supposed to say this out loud, but when she turned 40, did you have the kids call her and tell her happy birthday?
Believe so. Yes. Yeah.
You got any evidence of that, sir?
No.
Well, that's another one that we just have to take your word for it.
Yes.
Okay. Well, I'm going to show you what's been marked as petitioners 21. And I'm sorry, Ms. Lefevre, we talked about this one and it's got some blank pages, but they're just blank. I don't know why it came across like that. Do you want me to show it to him or what do you want me to do?
Hold on, let me pull it up.
Why don't we go ahead and take our afternoon break, give Minnie a break.
Yes, sir.
With the exhibit. Let's resume in 3:30. Court's in recess till 3:30.
Thank you. Yes, sir.
Ms. Mahoney, are you still there? No, okay.
I'm here.
Okay, I'm having a hard time knowing what it's actually like coming through because it's not every other page that's missing. It's like page 1 and then nothing on 2, 3, and 4, and then nothing on 5, 6, 7, 8.
But that's exactly how mine is. Okay, so I have page 1, page 2, I have just a blue question mark. I think it came through just like that. Page 3, I have just one picture. Page 4, I have a picture. Page 5 is just a box, it's blank. Page 6 is a blue question mark. Page 7, blue question mark. Page 9 is one picture. Page 10 is one picture. 11 is a picture, and 12 is a picture.
Okay, all right, then I think that's fine.
I can delete those pages, but this is the one I sent to him, and so I think it'd make it too.
It's fine.
Okay. All right, very good. Thank you. See you after the break.
What's going on? I don't see the meeting. What in the world is going on?
Alan, you're unmuted.
I can't see the meeting.
There's nothing on right now, but there you go. If you need to log out and log back in, we'll let you back in.
Yeah, I just logged out and back in because it made me leave or it kicked me off for some reason. So I'll try it again really quick. I'm gonna log off. Can you see me, Kathleen?
Yeah.
Okay, it's working then.